Right.
And then we went down to the sheriff's department. Then we took the one where you sit down and you blow through this tube.
So basically it was a blow and go for you. You blow in this and get in the car. Time to go.
Yeah, but I want to raise the point now.
With me, because balance disorder.
Did you tell them you had a balance disorder?
Yeah.
Okay. They felt real sorry for you, didn't they?
Blowed in that thing, took me to jail, blowed in that other thing.
It's in this. There's a saying that law enforcement has. It's you may beat the rap, but you're not going to beat the ride. If they decide that they're going to arrest you, you go into jail. Okay. Now you might beat it in the end, but you might beat the rap, but you ain't going to beat the ride. You're going to get to go to jail, and it's all up to the officer if he wants to take you to jail or not. That's the way it works. Anybody else have any questions? Now, I can't give any legal advice. I'm sure you're all represented. I just want to give you information, but not legal advice on how to do things. All right. Does anybody have any questions?
I got one.
Yes, ma'am.
Anytime they arrest you, just say for DUI, are they supposed to read you your rights?
Good question. You're talking about Miranda rights. Miranda has been under attack in the United States for the last several years anyway. Miranda is not required when you're arrested for DUI. Miranda is required when you're, now it comes into play in a DUI, and I've had it in several cases, but Miranda is required when you're arrested and they have you in custody. All right, you're in custody. That's after you've been arrested. Ma'am, I'm arresting you for DUI. Please sit in the back of the car. All right. At that time, they should read you Miranda before they say, you know, the other officer didn't give you these field sobriety tests. Can I get you to get back out, or will you blow in this for me? Right, at that time, Miranda applies. Right, you've been arrested, and they told you I'm arresting you for DUI, whatever it is. You've been arrested, you're in the back of the car. Now let's talk to you and question you and ask you for evidence to be used against you in court for the crime that you've been charged with. Right, that's what they're looking for. That's when Miranda applies. Now, you're not in custody in Georgia when the blue lights come on. When he comes up to the side of the car and says, can I see your license and your insurance and your registration, and walks to the back of your car and has all of your information, you're not in custody. When he gets you out of the car and is talking to you, you're not in custody. When you're doing field sobriety tests and doing everything he's telling you to do and walking the line, you're not in custody. Georgia considers you free to leave at any time.
What if you're sitting on a porch?
Well, then you get into they've got to prove that you were driving. Okay? There's a difference between Miranda and implied consent. Implied consent is a whole other topic we could talk about for a long time. But implied consent is what they read to you off the little card. They're supposed to read it to you off a little card after you've been arrested. Okay? They're not supposed to read you implied consent, ask you will you take the state administered test of your blood, breath, urine, or other bodily substances, and then so when you say no, they say you're under arrest. That's wrong.
They called me
Not
off
supposed
my
to do that.
court and just told me to blow in this tube. Next thing I know, I was arrested.
Well, they need to see you driving because they got to prove you were operating the vehicle within 3 hours of you being arrested.
You can't fight it, you just have to go with it.
Well, my advice to you is talk to somebody about it. Talk to an attorney about it. The thing about DUIs now is they're going to follow you. They're going to follow you. Anytime, you need to understand, Georgia doesn't have an expungement statute. If you're convicted of anything, if you're convicted of jaywalking, it's going to be on your record until you die. There's no expungement in Georgia. Now, if you're
Can you ask for an expungement?
Sure, you can ask for one, but there's no law that's going to grant it to you.
There's no automatic expungement.
There's no automatic expungement. Now, if they say you were driving the car, came up and arrested you, all right, and then the lady, your twin sister, comes up and says, no, it was me. I was the one driving the car. Remember they said they had on a blue shirt, and I got on a blue shirt. It was me driving. And she takes the hit for it. Right. Then, because they haven't moved any past you being arrested, you can expunge that, but a conviction cannot be expunged. Okay? And I have people come all the time that's got, felony charges from the 70s, this kind of thing that keeps popping up and keeps hurting their job, and they want to expunge it, but you can't expunge any of that, any conviction. It's going to be on your record.
And how hard is it to expunge things that are not a conviction? In other words, an
There's-
arrest, even when you're not even.
When you're not convicted or
Well, you're stating right here that the person can be arrested and not aware they're arrested. If you're not read the Miranda right, I mean, they obviously know they're arrested when they're put in handcuffs and put in jail and everyone walks off and they're standing there by themselves in
Right.
their cell. But prior to that, they could be arrested and not realize that they're under arrest.
Well, that's correct, because what you're looking at is arrest in the state of Georgia is basically when any reasonable person would understand that their liberty was infringed upon, their ability to freely leave was infringed upon. The way this works is the legal argument, as a defense attorney, and what I do a lot of times, the legal argument will not work with the judge that the person was in custody while they had the blue lights on and outside the car before they put the handcuffs on them. That legal argument generally doesn't work with the judge to say, even though at a hearing the officer will testify that the person was not free to leave. Because I asked the officer, and the officer, when you stopped him and you asked him for his license and his insurance, was he free to leave? Well, no. I said, could he have just driven off? And one officer said, no, I'd have given him a ticket for driving without a license on person. So, and then you take it a little further. Once you got him outside the car, was he free to leave then? If let's say he called a cab, and the cab pulled up and said, he lives down here, I can give him a ride right down to his house. Was he free to go? The officer will tell you, no, sir, he was not free to go. He was in my custody. Mm-hmm. Okay? That's what they'll testify to. I had a trooper do this not that long ago. What if his mama pulled up and said, hey, that's my son, he's a good boy. Can he just ride off with me? And the officer will tell you, no, sir, he can't go. No, ma'am, he can't go. What if he just walks over and sits down on the curb and throws his keys in the sewer? He can't leave. Can he do that? No, sir, he can't do that. He's in my custody. That argument does not work, that they should have read him Miranda rights. That does not work with the judge, because that's not the state of the law in Georgia. However, sometimes it works with the jury, because the jury is like y'all. The jury thinks, most people think, just like on television, you get arrested, they read you Miranda rights. Not the way it works. Now, where Miranda is not required is when you're sitting in the back of the car and you're begging that officer, to don't arrest me, don't take me to jail, I only had 4 or 5 beers, I only smoked 1 joint, this kind of thing. He's not required to read you Miranda, and everything that you say is either going to be written down or is on that video. That's the way it works. Everything. I had a case over on the coast a while back, and my client didn't do anything wrong on the video on his driving. However, he did do the forgot to put it in park thing and had to chase his truck down. But the officer did everything wrong that he could have done on the field sobriety test. Everything you can imagine he did wrong. My client was arrested. I watched the video. I was sitting there just chomping at the bits thinking, I like going places where people don't really know me. So they expect you to come in and just plead guilty and hang your head and say, he's a good fella, can't you cut him some slack, that kind of thing. And it's always, Mama said, you can catch more flies with sugar water than you can vinegar. So I'm nice as I can be, but when it comes time to fight now, you've got to get ready and roll your sleeves up and fight somebody. So what happens is I'm watching this video and I'm chomping at the bits. I'm thinking, this is going to be fun. This officer thinks he's done everything in the world. We're going to go down there and put on a show for these people. 35 minutes into the video, my client's in the back of the car going to jail and starts trying to bribe the officer. That's not a good thing. It's not a good thing to offer that officer $10,000. That's not a good thing. If you want to arrest me for DUI. That's when we knew that I didn't want that video being played in court. Because I was thinking I was going to use it just to hammer this officer, hammer him, and we didn't want that coming in. We actually were able to resolve that case satisfactorily because I beat up the solicitor enough with everything that officer did before we got to a video that they basically reduced the charge down. My client was happy. I told him he should be wearing tennis shoes if he wants to run away from that place. He was about like drive it like you stole it, isn't that what they say on the radio? That kind of thing. Other people were going to jail for DUI on golf carts. this kind of thing. So there's a lot of issues that you can get into when you're dealing with DUIs. Any other questions? Well, I appreciate y'all having me today. I've enjoyed talking to you. And if you don't have an attorney, you certainly don't have to come to me by any means, but you need to talk to somebody about your case, because these things are serious. And the DUI, not only will it remain on your record for your entire life, but it will count against you for 10 years. So if you've got a DUI from 9 years ago and you get one now, it's your second. All right, y'all need to keep that in mind. It's not the 5 years anymore. It goes back 10 years. The look back period is 10 years. I appreciate y'all letting me come. Thank you, ma'am.
Thank you.
Let me ask you something within 10 years.
Ma'am, they look back on all. They look back on your second and
Just
10.
for setting probation, because it's not on driver's license.
Yeah, well, it is. It's for sentencing, not on the driver's license.
Right.
It's for
Driver's
sentencing.
license is still,
A 5-year look back.
there's no look back 10 years on your first, second, or third one. But on that fourth one, they can go back 4 years and declare you habitual violator.
That's right.
Or within 10.
That's right. It's on
Now,
sentencing.
After July 1st of '08,
That's right.
if you get a DUI in '09, you get another one in 2010, but you don't get another one until 2019, that'll be your third one. Because it does go back to July 1st of '08 on
That's right.
driver's license after.
That's right. It does. What I'm
Right
talking
now.
about is sentencing.
Right.
And the sentencing gets right on up there. The local judge recently, it's my understanding, sentenced a young lady on a first DUI to 25 days in jail after a trial. Wasn't my client. Accident, nobody hurt, no second vehicle involved. First DUI, wasn't a high blow. This is all my understanding, 25 days in jail. Yeah, you can go to jail for DUI up to 12 months. Sit in the county jail for 12 months. If the judge wanted to send you there. Sure can. Sure can. It's serious business. I mean, it's not, you know, of course they want you just to come in and plead guilty, pay your money, and go on about your business. Now you convicted of DUI, see you next time. Okay? And that's sort of what they want you to do. And used to, you might be able to get away with that. No-load doesn't work anymore. You can't you can no-load. You can no-load all you want to. I've gone to city courts before where they said, who wants to plead no-load? People throw their hands up, run up there, they plead no load, they thank them, appreciate your money, be on probation now for a good while. When it goes to the state says convicted. They take the driver's license, the whole 9 yards. Also, a marijuana conviction now will suspend your driver's license. You could be walking down the street smoking marijuana or having it on you, and that will suspend your driver's license. You don't have to be driving. Okay? Any other questions?
So no-low is just,
No-low is, a no-low, the whole process of no-low is no-low contender, is what it means, no contest. I'm not saying I'm guilty, I'm not saying I'm not guilty, I'm just saying I'll just pay you fine, I'll do whatever, I'm not going to admit guilt, is basically what no-low contender is. That used to be effective on a DUI, you could do that, and it wouldn't suspend your license. Now it does. When it hits, you can do it, it'll say no-low, all the right language will be on your stuff, but when it gets to the state doesn't care. Treat it as conviction. Okay? Any other questions? I appreciate y'all putting up with me this morning.
Thank you.
Thank you.
Thank you.